Start with the Supreme Court this morning. Just a couple of hours, we'll hear oral arguments on Donald Trump's eligibility for the Colorado primary. Back in December, you'll remember, Colorado State Supreme Court ruled Trump should be removed from the state's ballot based on Section 3 of the 14th Amendment to the U.S. Constitution. The post-Civil War provision of the Constitution bars anyone who took an oath as a member of Congress or as an officer of the United States and engaged in insurrection from holding public office again. Trump's legal team is expected to argue that as president, he was not an officer of the United States and that his actions leading up to and on January 6 do not constitute an insurrection or rebellion. Let's bring in former U.S. Attorney and MSNBC contributor Barbara McQuade. She is co-host of the Sisters-in-Law podcast. Barbara, good morning. It's great to have you with us. So what do you expect to see today as this gets underway?
Well, I think we know what the arguments are just because all the briefs have been filed, all the amicus briefs have been filed. But what I'll be looking for and what I think we can expect are the questions that we hear from the justices themselves. That will be a real indicator as to whether they're going to go to the meat of this, looking to see whether Donald Trump engaged in an insurrection, or instead they're looking for some sort of off-ramp to sort of dodge the big question. And as the justices ask questions, what'll be interesting to hear is the focus of those questions, but also whether some justices are using their opportunity to ask questions as sort of advocate for a particular position or another. That's what makes it so fascinating to listen to the oral argument.
So, Barbara, obviously the Supreme Court, any court, is supposed to stick to the law. 14th Amendment, Section 3 in this case. But there are obviously larger implications here. We've heard even some Democrats, we've heard some allies of President Biden on other networks saying they worry about the implications of keeping Donald Trump off of a ballot, what it means for the country, what it means for telling voters you don't even get a chance to have your voice heard here. Does the Supreme Court bring that into its decision ultimately?
I don't know. You know, Chief Justice Roberts has his hands full here because I think we are at a moment in our nation's history when public confidence in the Supreme Court is very low. And so I think it has to be at the back of his mind that he doesn't want to do anything that makes that worse. And if anything, he wants to bolster confidence. But it's difficult to know which way that cuts. Removing Donald Trump from the ballot, I suppose, would be putting the court at the center of American life. And perhaps he would like to avoid being the decision maker that removes a presidential candidate who is leading his party for the nomination. On the other hand, Clarence Thomas himself has said it is not the job of the Supreme Court to render extinct language from the Constitution. And so to say that, well, he's popular, so we should just forget about worrying about the 14th Amendment. It is the job of the court to interpret the law. And so I think that they're a little damned if they do, damned if they don't here, because if they say, no, you know, the voters should decide, that would really abdicate their role as the court to interpret the law.
So let's talk about what their job is, because obviously influencing public confidence is not the job of the Supreme Court. What is the question at hand here that they have to consider? Because I think a lot of people might listen to this headline and say, oh, well, he wasn't there at the Capitol. He didn't break a window. So there's no way that Donald Trump did what this claim is saying. But this is talking about engaging in insurrection. Am I right? And as a result, is it possible that could be proven?
Well, yes. And in fact, if you look at the language of the Section 3 of the 14th Amendment, it says not only that someone engaged in insurrection, it also says or provided aid or comfort to those who did. And so I think there are a number of ways, just as the Colorado Supreme Court did, to find that Donald Trump did indeed engage in insurrection, which would bar him under this clause. For example, the speech he gave at the Ellipse and the tweets he sent even after the attack was underway could be a basis for engaging in insurrection. However, if there is a worry that that violates any First Amendment rights that he may have, I think a stronger argument is that he provided aid and comfort to the same. Because as president, unlike the rest of us, he actually has affirmative duties to take care that the laws be faithfully executed. And so his failure to call off that insurrection after 187 minutes, I think, is maybe the strongest argument that he provided aid and comfort to those who were engaged in insurrection, and that would bar him as well.
And Jonathan Lemire, I mean, not only did he say, go to the Capitol, I'll meet you there, and they all went running to the Capitol. Since then, he's called the people who are doing hard time right now for the insurrection that he instigated, he's calling them hostages. He had, I think, a convict choir at one of his rallies. I mean, he continues to give them comfort and to accept them as part of something normal.
Yeah, and he, of course, spent months spouting the big lie, which is what primed that insurrection. And then he appeared before the crowd on the Ellipse on January 6th and whipped them up into a frenzy, even saying he would go with them to the Capitol before changing his mind and turning back and heading to the White House. And certainly ever since then, he has only praised those who fought for him that day. And we know that he watched in a little television off the private dining room off the Oval Office and cheered on some of the more violent moments of the insurrection that day. So, Barbara, it's also, of course, important because it's not just Colorado. There are other states considering similar measures. If this were to go through, the Supreme Court's got to step in, set sort of precedent. So walk us through the mechanics of what will happen today. Who's going to speak for how long? And then, most importantly, what happens next? When will we hear from the Supreme Court as to what they decide?
So they have set oral argument to allow first the appellant, which is the typical case, the party who is seeking to overturn the prior decision. So the lawyers on behalf of Donald Trump will argue first. We'll hear from them. And then the response will actually be divided among two different lawyers. One lawyer representing the voters of Colorado to represent that interest of not having an insurrectionist on the ballot. And then also the Solicitor General of the state of Colorado representing the Secretary of State of Colorado, who has slightly different interests, which is I need to know whether to put this person on the ballot, and I have a duty to remove people who are not qualified. And so we'll hear from both of them, both arguing against Donald Trump being on the ballot, but with slightly different interests there. So we'll hear those arguments. And as I said, to me, the most interesting part of listening, and it'll be streaming live at 10 o'clock, I know, right here on MSNBC. And I think what will be most interesting is to listen to the questions, because sometimes that can give you a hint as to what is on the mind of the justices. And then your very good question about when can we expect to hear an answer. I think it will come quickly. You know, most of the time, these big issues are not decided until late in the court's term, June, even into July sometimes, because it just takes that long for them to exchange opinions and reach consensus on things or draft dissents from those majority opinions. But one of the things we've seen here is amicus briefs filed by secretaries of the states, of other states as well, saying, I need to know the answer to this question because I need to send out ballots for the primary election in my state. And so I would imagine that brings a sense of urgency to the court. And we have seen that from time to time when they really need to decide something quickly, a quick decision. So I don't know that we'll see it overnight, but I think we may see it in a matter of weeks just because of the urgency of this question.